Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV130588, Boisson versus Arizona Board of Regents et al. We are recording today's proceedings both by audio and video recording. So when you step to the podium, if you would, please identify yourself and the client that you represent. Each side will have 20 minutes for argument, and Mr. Abney, as appellant's counsel, you're responsible for watching the clock and reserving any time for rebuttal that you might desire. And the appellees will have 20 minutes to divide as you see fit. We have read the briefs in this case. We've conferenced the case prior to argument. We believe we understand the facts and hopefully the legal issues as well. So with those preliminaries, Mr. Abney, you may proceed.
May it please the court. My name is David Abney. I'm here today with my partner Dana Roberts, and I'm also here with Cyril and Elizabeth Boisson, the parents of Morgan Boisson. The issue that resolved the case at the Superior Court was whether reasonable jurors could conclude that the Tibet excursion was in fact a school activity. The trial judge decided no. We believe that that was incorrect, and on a de novo review, this court can and should decide that there were sufficient facts that reasonable jurors could at least infer that this is a school activity, even if they could not directly make that conclusion. There are a number of facts in the record. This was an excursion that could not have taken place at all without the extensive, heavy involvement of Nanjing. In the first place, there was no time to go, so Nanjing made time in the school calendar for the trip to go forward, and also made provision for work that could be done as makeup when the excursion was done. By doing that, Nanjing actually defined the parameters of the trip, how long it could be, how many days, which had deadly effect later on because the trip was too short for proper acclimatization to the extreme altitude differences between the surface, basically sea level where the program was, up to 11,000 feet at Lhasa, the capital of Tibet, and then 18,000 feet at the base camp. The group went to Lhasa one day. The very next day, they were in Lhasa, and then the day after that, they went all the way up to 18,000 feet. And when they got there, actually when they got to Lhasa in the first place, Morgan started displaying symptoms of altitude sickness. And by the time they had made it to the base camp, the symptoms were extreme. The students, God bless them, did the best they could. They tried to arrange to get a bus to get down the mountain as fast as they could, but Morgan died very quickly after the onset of the severe symptoms. The problem is that under the standard of care, Nanjing should have made sure that the students were fully informed about what was to happen as far as the dangers they would confront in Tibet. Not simply the political dangers that were the source of having to get a special permit, travel permit from the Chinese government, without which they could not have gone.
Isn't the threshold issue duty? And do we have to decide that before we even get to standard of care and whether there was a breach of the standard of care?
In this particular case, duty was accepted by the Superior Court. Well, let me say yes, and then go on. As a threshold issue at the Superior Court, the trial court had no problem with the concept that there is a general duty of care for study abroad programs. That's evidence from its discussion of Restatement Section 40 and the remarks that it made before it got to what it regarded as the dispositive issue as to whether it was a school activity. In its answering brief at pages 3, 28, and 46, Nanjing admitted that there's a duty of care. And in its answering brief at pages 10 and 14, the Board of Regents admitted that there's a standard of care, that there's a duty of care, sorry. So the duty of care has been admitted. I don't think I can create a duty of care simply by admissions of the party or even by a ruling from the Superior Court. But when you think about it, this is...
I think you have to be a little more accurate about that in terms of they admitted that there is a general duty between colleges and students or schools and students, but I don't think that they admitted that there was a duty for this off-campus activity that they believe was not a school activity. I don't recall reading anything in the briefs where they admitted that duty.
No, they did not. And the court, the way it phrased it is, there is no duty of care for this activity. But there is a general duty of care for your study abroad program. Then the question really becomes, the specific question is this Tibet excursion a school activity?
And that comes from Restatement Section 40, the standard in Restatement Section 40.
The general standard of care, yes, because Restatement Section 40 has recognized there's a special relationship between schools and students. And its remarks are actually very interesting. It talks about what's important is the standard will vary from if elementary students to college students. There's going to be differences in the standard of care. But there is a general duty. So that takes us to the very specific facts question.
Counsel, I do have to ask you, you cited the restatement section 40, but that's entitled duty based on special relationship.
Correct.
It doesn't really discuss standard of care, and it talks about a school with its students generally, and then there's a lot of examples.
Right.
So,
there is.
Maybe I misheard it, but I thought I heard you saying that the restatement's talking about standard of care when it's clearly talking about duty based on special relationships.
What you might call the black letter part of the restatement specifically deals with special relationship and duty. And when you get into the commentary, it has some very interesting comments about, well, the standards will differ. What you have to do to fulfill the duty of care will differ depending on what kind of student group you're dealing with, elementary students, and it actually mentions college students as well. And there of course, there are huge differences. An elementary school group that's on a study abroad program in China or a high school group is going to be under different standards of care than a college group. And that's where we get into Dr. Hoffa's declaration, which dealt very, very heavily with all the standards of care for study abroad programs.
Doesn't Section 40, though, really talk about the scope of the duty?
Well, it defines, in a way, yes. It defines, it says that there are certain special relationships that have a duty that go with them. Lists a number of them, and one of them is student and school.
And then it talks about on-campus activities and other school activities, which
right.
presumptively are off campus.
Right.
Okay. And isn't that sort of an analytical framework to see whether a duty is owed?
Sure.
Okay.
It has to be a school activity, whether it's on campus or off campus. That's the point, is that it's a school activity. It's not a school activity. Who cares?
Well, I suppose, and this is not this case, but the duty could exist on campus even if it wasn't a school activity from a property owner's perspective.
Sure.
Fair? Okay. But that's a hypothetical we're not asked
right.
to decide.
And you get such a blend there when you talk about activities on campus, duties as a landowner, duties as a property manager, and it really is, I think it all goes back to the very special situation with students on campus. But you still have that special relationship wherever the students are. Dr. Hoffa explained that a study abroad program is something that's different, it's special, and that it's the entire program falls within the standards of care. There are a number of standards of care specifically related to excursions and specifically related to excursions in hazardous areas, such as Tibet. Hazardous not only for the political situation and for the very severe climate, but also for the altitude. It's a dangerous place to go. And when you're dealing with an excursion, Dr. Hoffa says, well, you have to do a number of things. You have to investigate. You have to find out what the dangers are of the area of the excursion. You need to inform the students reasonably about what the dangers are. You need to make sure.
Doesn't that turn on whether it's a school activity or not?
Yes, but his conclusion was that when you look at a study abroad program, everything that happens during the course of that program, including excursions, whether by individual students or groups of students, whether accompanied by a teacher or unaccompanied by a teacher, those are all part of the study abroad program. You can't divide it into segments.
And I appreciate that, but under Section 40 of the restatement, that takes a somewhat different approach, it seems.
Well, it's a complementary approach. The restatement is saying if it's a school activity, whether it's on campus or off campus, there's a duty. And Dr. Hoffa is defining the factual question as to whether should this be considered a school activity or not. And from the perspective of the standards for study abroad programs, an excursion, especially an excursion to a dangerous place, is a school activity. And there's certain.
Is that a factual issue or is that a legal issue the court decides?
It's a factual issue.
And what's the authority for that?
Well, the authority is first for, I think, my brain is failing me here, but the Arizona cases that deal with duty say duty is for the judge, standards of care are for the jury.
And I think we may be saying the same thing, but I want to better understand what you're saying in that respect.
The duty issue, I submit to the court, is resolved. I mean, Section 40 resolves it. The trial judge accepted it. The parties all say there is a duty of care, and there is a general duty of care. And indeed, how could there not be? Anytime you have an enterprise where you're inviting people to participate, you have some sort of duty of care to those people. What exactly it would be gets into the standards of care. And standards of care are for the jury. That's Arizona. That's solid Arizona case law. And the trial judge recognized that in his
Counsel,
ruling.
Can I read you a section? This is from the restatement. This is subsection L, duty of schools. And it says here, such a duty has enjoyed substantial acceptance amongst the courts since the second restatement's publication. As with other duties imposed by this section, it is only applicable to risks that occur while the student is at school or otherwise engaged in school activities.
Exactly right. And that's my point.
So what the restatement says is that the duty applies if they're engaged in school activities.
Exactly right. But how do you decide whether they're at school or off school? Okay. It's a question of fact, always.
But how do you resolve that approach with the language in Gibson, which cautions us against a fact-specific analysis of the relationship between the parties in determining whether a duty exists?
There's nothing very fact-specific about the first part of the inquiry, which is the existence of a duty. Are you a student at a university engaged in, are you a university student? The university owes you a standard of care, owes you a duty. Exactly what the standards are will vary. There's extreme variation between what you need to do for kindergarten kids and what you need to do for college kids. But the duty itself is settled across the board. There is a duty of care. And then you have to decide, well, is this an activity of the school, on campus, off campus? That's a fact question. And that's really what the judge, that's how the judge decided the case. When he said the only potential question of fact is whether the students were engaged in a school activity when they made their trip to Tibet.
So the jury has to decide whether there's a duty?
No, the jury doesn't decide the duty.
Fact issue, whether it's a school activity, then that must be decided by the jury, is what you're saying. So
yes, of course.
So the jury has to decide whether there's a duty?
No, the jury decides whether this is a school activity. If the jury decides, yes, this is a school activity, then the duty of care would apply. If the jury decides that it's not a school activity, no duty of care applies. The duty of care is there, overarching everything else. And
you may be right on that. I'm not suggesting you're not, but that's not what the restatement says. The restatement talks about the duty in terms of the scope of the duty, the legal duty. Is it a school activity or not? It's not. It doesn't describe a freestanding duty of schools to all students in all situations in all locations. That's not what it talks about. It talks about here in terms of off campus, the duty exists if it's a school activity. You're saying that's a factual issue.
Yes.
And that if so, then you're not relying on the restatement, because the restatement says that's an issue of duty.
No, I respectfully disagree. I think the restatement is saying there is a duty of care because of the special relationship. The duty of care is confined within certain limits. There has to be a school activity either on campus or off campus. But the determination of whether it's on campus or off campus is simply a question of fact. Was Johnny at school that day? Was he in the playground, or was Johnny walking home and not at school? Was Johnny on a field trip? And were these students in a study abroad program in China and then in Tibet? That's a fact question.
Counsel, let me ask you, it seems the approach that you're suggesting we take is different than the approach that Division II took in Monroe. But enlighten me. Help me understand your position with respect to Monroe.
The point here is to identify, as in Delbridge and the other cases involving the community colleges, is this a particular activity that is a school activity? Once you identify that as a fact question, the answer of duty, which is already existing above you, is really answered. Yes, there's a duty. So, I mean, that's the best I can do about that. There is this overarching duty, but it applies in certain fact situations, and the jury has to decide whether that fact situation exists or not the judge. I'd like to make a few comments about the $1 and $6.5 million issue that came up. At the close of our argument on the motions for summary judgment, counsel for the defense said, "Oh, and by the way, I have the danger of death in Tibet from altitude sickness is $1 and $6.5 million." No evidence in the record to support that. The judge was fascinated by that, and I filed a supplement to correct the misimpression that had been made. The defense's own expert had said that the risk of serious injury or death from this particular trip was 1 in 50.
And why does that matter given Gibson's statement that foreseeability is no longer the issue?
Well, as I said, and it's probably never the greatest analogy, but there's a bell that gets rung when you say that the risk of injury or death is 1.65 million. I mean, it's statistically almost insignificant. When the defense knows from its own expert that the risk of death for this specific trip is 1 in 50. And I believe we had the right to correct that misimpression. I think there's certain things you simply cannot take back, and it will resonate in a juror's mind and in the judicial mind no matter what you do unless you take some steps to correct it.
But what, in this case, the record comes to us with the trial court saying, striking filings, and saying that that was not considered. How do you suggest we deal with that?
I suggest there are some things you simply cannot erase from your mind, and even the well-intentioned thoughts of the trial judge, well, I'm going to wash this from my mind, I think you cannot take those away, first. And second, I think there's some things that you just don't do. You don't go into court and say, well, the risk of death is only 1.65 million, 1 in 6.5 million, when you know your own expert has said for this trip it's 1 in 50. You just don't do that sort of thing, and we had a right to correct it.
Asking us to do, we review it de novo anyway, so what are you asking us to do vis-a-vis this argument?
I'm asking you to unstrike the judge's striking of our supplement is what I'm asking.
Well, and just to clarify, we review that issue for an abuse of discretion.
You do, Your Honor,
okay.
and it's an uphill fight, and I understand that, and I understand the judicial grimaces, but I'd like to reserve my remaining time.
Thank you.
Thank you.
Counsel for the athletes.
Good morning, Your Honors. My name is Janet Linson. I'm here on behalf of Nanjing American University. I also have here Shauna Warner on behalf of Arizona Board of Regents and State of Arizona. I will be addressing the duty issue and also will be taking questions if the court has them regarding the damages, but I would like to reserve some time for Ms. Warner to address any issues specific to her client. So let's start with the threshold issue, which I think we've all identified, which is duty. And as the court has already recognized, a case came out this year, Monroe versus Basis of the Court of Appeals, which recognized Restatement 40, Comment L, that the scope of duty imposed by the student-school relationship is not limitless. And as this court has already recognized today, in a student-school relationship, the duty of care is bounded by geography and time, encompassing risks such as those that occur while the student is at school or otherwise under the school's control. So it's well established that schools simply do not have a duty to its students when they are not engaged in school activities. The holding in Monroe was basically that the school did not have a duty for an 11-year-old fifth grader traveling to and from school. In that case, the fifth grader was struck while crossing a crosswalk about a block away. So taking that in the context of this case, which involves adult students, adult college students, it makes sense. It seems obvious that colleges do not owe a duty to adult students who are out and about town, off campus, doing whatever they please. Likewise, the U of A, for example, would not have a duty for students who decide on spring break to go to Rocky Point and do whatever they do down there. Just because they are students does not mean that there's an overarching 24/7 duty at all times. And I think that the restatement clearly sets that forth, and as well as Monroe.
But Monroe decided a different factual issue, didn't it?
Sure.
It was the allegation, as I recall, was that the school had a duty to do something more with these crosswalks, that the school had just done nothing. and that they should have done something. Here, doesn't the appellant say, look, the school did some things. The school, reorganized classes, allowed classes to be made up, helped with a letter to the Chinese government, and helped with communication for Tibet tours. So isn't this case somewhat different than Monroe in that respect?
It is, Your Honor, but I would submit to the court that in Monroe, the court talked about, well, had basis undertaken to have a crosswalk, to have all those things, they would have had the duty to do those things correctly. In this case, the things we did, such as collecting information and sending it to Tibet tours in order for Tibet tours to get a permit, those things, there's no allegation that those undertakings were done negligently, nor is there any allegation that changing classes in any way was negligent. So when we talk about undertaking, we have to think about what is the cause of that, and is it the allegation neglect in the undertaking? And here there's no allegation of that.
Let me ask you, though, because duty can arise in a variety of different contexts, and I see from a variety of different sources, and I see from the briefs that in this case it seems like largely the duty has its origin or doesn't, depending on which table you sit at, in Section 40 of the restatement, and then there's at least atmospherically some public policy arguments that are largely in the answering briefs and the reply. I didn't see this as an undertaking case, but help me on that, because you've now mentioned that.
Right, exactly, and that was my point, is that this is not a negligent undertaking case. Essentially, what appellants are arguing is because we assisted in some way, because we helped facilitate by sending information and by changing class, that means that this trip was a school activity, and that simply is not true. Given the factual record before this court, the overwhelming, uncontroverted facts are that this was not a school activity. This was not an official excursion by NAU. It was not planned, coordinated, sponsored, anything. The only things that NAU did were help to send information to the tour company and change classes. And I think that changing classes actually helps the idea that this was not a school activity. If it was a school activity, why would there be classes planned during an official excursion? It makes no sense.
Who decides whether this is a school activity, the court or the jury?
I believe it's for the court's discretion. And I think that it's clear, Gibson versus Casey makes clear that the issue of duty is not a factual matter. It is a legal matter to be determined before the case-specific facts are considered. It's clear, the law is very clear on that. This is a matter of law. This is an issue for the court to decide, not to the jury. And I do recognize that the trial court did say all reasonable jurors could not see this as a school activity, and I echo that in my brief, but I believe that that was actually incorrect and inaccuracy. Really, the issue of duty should be determined for the court, and the guiding principle is that the courts will find a duty where, in general, reasonable men would recognize it and agree that it exists. And that reasonable man standard really, or woman, pertains to the court. It does not pertain to a jury. So here we have the facts set forth that are, again, uncontroverted. But before I get to that, I just want to address, again, what we're talking about when we talk about duty.
Let me, before you get to that, push
Sure.
you a little bit. You said the facts are uncontroverted, but in your construction, what you just described as to whether it's a court's decision or the jury's decision, why is the fact that facts are uncontroverted important?
Well, I think that if there were a question of fact as to whether, for example, we actually move classes, if there was a question of fact as to whether, Decine actually went on the trip, if there were those types of fact questions, perhaps that would be something for the jury to decide. But because on this record there are no uncontroverted facts, It's for the court then to take those facts and apply that reasonable man standard and say, does a duty exist? And really what that boils down to, according to the restatement as well as Monroe and all the other line of cases that were cited, is whether this was a school activity. And that is a question of law for the court to decide. It can't be dictated by expert opinion, that's clear. So no matter what Dr. Hoffa thinks about whether there should be a duty or not, should not be considered. No expert, no matter how qualified, cannot dictate the law. That's solely for the court to do. And duty is not about what defendant could have done, and that kind of ties in with this idea that, well, they shouldn't have changed classes, they shouldn't have sent information. Markovitz makes clear, the Supreme Court makes clear in that case, that the concept of duty is not a question of whether the danger was natural, artificial, obvious, or whether defendant should have searched for, warned of, or removed the danger, or have taken any particular action. The question is whether defendant was responsible to take any precaution to protect the plaintiff. And that's the question here. The question is, does NAU owe decedent a duty with regard to the Tibet trip? Not, could we have stopped
Counsel,
it?
It almost seems like you're arguing that even though Gibson cautions that duty is not based on, fact-specific determinations, that the court, the trial judge, has to make some findings of fact implicit in determining whether or not there's a duty? Is it an all-or-nothing situation, or does the judge have to consider some facts to decide whether a duty exists in the first place? In other words, is the language in Gibson perhaps being stretched too far to say no fact determinations at all can ever be considered in deciding whether a duty exists?
Right. Well, I think that when we look at the language in Gibson and actually look at that case, the court did consider facts. I mean, in order to define whether there's a duty or not, you have to look at the facts of the given case. In the Gibson case, they had to look at the relationship between the coworkers, between the girlfriend of the coworker, and they had to look at what the people knew, and they considered all those things, and those are facts, but it's simply impossible to determine duty without actually considering some facts, considering what you're faced with in the case. In terms of, speaking on that, in terms of the facts here that are before the court, I just want to be clear that there is a distinction between official excursions and independent travel, and that's really the key to this case. NAU did offer official excursions to Beijing, Shanghai, and Hangzhou during the fall 2000 semester. Those trips were planned, coordinated, sponsored by NAU. There was faculty that attended those trips. Lodging was provided, activities were pre-planned for that trip, and all the students were required to go. It was part of the curriculum. On the other hand, there were independent side trips that the students took, such as, the Tibet trip. And the students themselves state that the Tibet trip was an independent side trip, and the facts support that. The students conceived of this trip when they got to Nanjing on their own. They organized it, they planned it. Marcus Nielsen headed the research and coordination of the trip. He's the one that found Tibet Tours. He's the one who contacted Tibet Tours and booked the tour on behalf of all the students. Tibet Tours was the company in Tibet that planned the itinerary, and Marcus Nielsen told Tibet Tours, well, our goal is to see the sunrise over Mount Everest. So he was dictating, here are the activities we want to do. It was not NAU that was involved in any way. Further, the students paid for the trip on their own. In fact, Mrs. Basson paid Tibet Tours directly through PayPal. It wasn't payment to the school, which was the case with official excursions. The payment there was through the tuition, basically, was included in the tuition. It was Tibet Tours that arranged and obtained the permits that we're talking about to go to Tibet. They provided all the transportation to and from the airport within Tibet. They provided an English-speaking tour guide that was approved by the government, given that when you travel in Tibet, because of the political unrest, the government requires that you have a sanctioned tour guide with you at all times, and Tibet Tours provided that for the students.
The government also required, didn't it, a certification or a letter from your client?
Yes.
And was that, and I'll probably mispronounce this, but is Zhang Fan?
Zhang Fan, yes.
What's your response to appellant's argument that, look, but for conduct by your client, this trip never could have happened?
Well, again, the question before the court is duty. It's not causation. And you know, when you ask but for, that's implicating causation. But
my term, I think they use a more
okay.
elegant term than that. But,
right. But in terms of the permit, whether this created some kind of duty or this turned the trip into a school activity, I would submit that it did not. That was a requirement. You know, all what Nanjing had to do was just certify that these were students. And an analogy to that would be if a school provided you a transcript because you needed to get a job, or provided you other, you know, information such as that to allow you to go on to do other things independently. Does that create a duty?
Well,
I don't think so.
Don't appellants argue that Fan actually did a bunch more than just that? Fair?
I believe, yes. She also negotiated a discount for the air ticket.
And served in some respects as kind of a communicator.
Right, a translator
right,
with the airline, yes.
And again, you know, how far down the road toward a duty does that take us?
Well, I think, again, this is not a negligent undertaking case. So there was no negligence alleged in that. But to go further and to try to answer your question, the airplane ticket itself was not part of, you know, that was not the danger here. The danger here was going from Lhasa at 11,000 feet to Mount Everest Base Camp at 18,000 feet. So just helping to get the students to Lhasa in and of itself was not the danger here. And that's all Ms. Fan did, was to help negotiate a discount for an airline ticket. So in terms of the damages claim, I think that the statute is very clear on its face, and the Downs case that the appellants rely on is outdated law given the 1956 amendment to the wrongful death statute. In terms of the loss of inheritance claim, I mean, based on their experts' own opinions, the probability that the parents would outlive the decedent was 0%. So I'll stop with that unless the court has any other questions, and I'll turn it over to Ms. Warner.
Thank you.
Thank you.
Good morning. May it please the court. My name is Shauna Warner. I'm here for the State of Arizona, Arizona Board of Regents. And pardon me, I'll speak quickly and kind of spotty because I wanted to cover a few areas. Judge Thumey, you had asked about the conflict between the Restatement 40 and the approach of Dr. Hoffa, which seems to be a portal to portal. No matter what happens, this is a school activity, and you're absolutely correct. And Monroe, as you all have noted, tells us that the duty exists only within the confines of that relationship, which is bordered geographically and temporally. And if we look at Monroe, which was decided as a matter of law by the court properly, of course you have to consider facts to do that. Trial court judges do that all the time. We're contrasting an 11-year-old girl temporally within minutes of school being out, geographically within a block of school, and traveling a very busy intersection. And the court said, no, she's not there, school's out, that's it. And we're contrasting this 11-year-old girl, minutes after school, geographically within a block, to a 20-year-old man, 2,500 miles from the forum location for the study abroad program, 8,000 miles from the U of A and days away from his last class at Nanjing American University.
Let me ask you, though, and I want to make sure I understand your brief correctly. We've talked about Section 40 of the restatement quite a bit. Is it your client's position that that sets forth the standard that this court should properly apply?
Because the court ruled on that issue, it did not need to reach the issue of whether, when it applied in a study abroad program to the study abroad provider, whether that would then relate back to the domestic university 8,000 miles away. The court didn't need to reach that. We haven't fully fleshed out the facts or law on that. Our position was, and I will tell you, I came into the case late and they were filing their motion. We joined and I think noted in the briefs that because the only allegations against the University of Arizona were secondary to or alleged to be vicarious for that provider, if they were released, as in all of the doctor hospital cases, and if they were released, that would be a release of the university as well. So we did not get to all of those issues before the court.
But you don't take a position inconsistent with the restatement, Section 40?
No, Restatement 40, if you know, and I think the Supreme Court denied review this year on that case. It was just decided this year. That's the most recent pronouncement, and contrasting the two, I think there's really no question. Another question I think was a good one that was asked about a trial judge considering facts. And essentially what Dr. Hoppe wants to do is what Dr. Litvak was told he cannot do in the Flores-Sargent case. When the trial court looks at the unsound mind determination, that's a fact, that's a question of law for the court, but it involves facts. Do you have a checking account? Did you hold a job? And when the court looks at that and says this person did not have an unsound mind sufficient to toll the statute of limitations, it doesn't matter if Dr. Litvak says, well, yes, he had an unsound mind. I say he had an unsound mind. I'm a psychologist. It doesn't matter in much the same way whether Dr. Hoppe says it's a school activity.
Counsel, let me ask you this question. We talk about public policy and the duty of the college. Is it your argument that these colleges should allow these students to go to countries like China, where they face all these risks, and no matter what they do, unless it's supervised by the university, they're on their own and they're at their own risk? I mean, is that really what we want to be setting the standard for these colleges? Is go to China, but unless you're on campus or you're following our supervised tour, you're on your own. We don't have any duty to you at all.
I don't think so, Your Honor. And I would first mention in the Collette case, the Tolleson Unified School District case, the court said in high school setting where the students were coming back 72 miles an hour to class to try and make it, and they were in violation of their closed campus policy, they said students aren't prisoners. We can't control their conduct. There has to be a balance, there has to be a weighing, and we don't have cases. Mr. Abney's an excellent appellate advocate. I know he's down here all the time. If there was a case talking about that yet, that hasn't been framed, what these duties are. But what this case is not about is a situation where the forum jurisdiction was crime-riddled, didn't have access to health and sanitation, where there had not been a vetting process as to the program. Mr. Hoppe has virtually no criticisms of the program aside from the safety of not even just this trip, but the itinerary set by Tibet Tours and Mr. Nelson for this trip. So, you know, the pedagogical exercise of what ifs, I'm afraid we probably will have to come to that. We're becoming a global world. But this doesn't involve a situation where, I mean, the U of A said that there's no duty at all. Of course there's a duty. My heart breaks for these people. I have 3 daughters in college. So that's not at all the situation where we're suggesting that we're just turning these kids out in the universe. But students are going to travel, whether it's through the court or independently. And frankly, you know, public policy says, let's see that it's through these programs as opposed to a bunch of kids with backpacks. I'm sorry. If there are any, I didn't even get to talk to the punitive damage issue, but I think that's fairly well briefed.
Thank you. Okay. We'll add a minute to Mr. Abney's time since appellees went over about a minute.
I was thinking more of a half hour, but
We'll erase that from our minds and forget you said that.
yeah, sure. And I know that the judicial mind is very powerful. Just on Monroe, I would just want to add a statement out of Monroe, quote, well, they talked about the general rule of school control and duty, and then they say, quote, then they say that, quote, does not mean that a school never has a duty to protect its students beyond the school's physical boundaries or outside of normal school hours. So they were actually leaving the question open that we're dealing with here. As far as the restatement, comment L, I don't have it in full, but I do have the central quotes. They're talking about the student of care, and they say that it applies to, quote, a wide range of students. And then, quote, reasonable care is contextual. The extent and type of supervision required of young elementary school pupils is substantially different from reasonable care for college students. And of course, this gets me back to the central problem, and the one that really is the trigger for everything else. Was this a school activity? It's hard to imagine a more fact-intensive question, and one that is it's incredibly disputed in this case. We have a great deal of evidence about the extensive steps that Nanjing took. It wasn't just trying to get a discount. It was arranging for tickets. It was copying passports and other student identification documents and providing those to the Chinese government. It was providing the Chinese government with a letter of university approval so the students could go at all. Without that letter, they would not have gone. It involved reshuffling the schedule and setting out a block of time, as it turned out to be an inherently dangerous block of time, for the students to go to Tibet. They made it possible in a scholastic sense that they could go, and in a physical sense, and in a legal sense. Nanjing had utter control over whether this excursion was going to go forward or not. Then we have Dr. Hoffa. They did not provide any counter evidence to what Dr. Hoffa said. They criticized what he said with lawyer argument, and that's fine, but they had no counter evidence to what he said. And when they talk about, is this a portal-to-portal standard of care? Yes, according to Dr. Hoffa. And according to him, he specifically concluded that this Tibet excursion was part of the overall study abroad program. And he laid out a number of things for the standard of care that really reflect back on whether this is a school activity or not. The duty to investigate, the duty to communicate dangers to the students, the duty to make sure that the students understood where and how they could get emergency care and where and how they could get evacuation. On top of that, a direct duty to make sure that there was emergency medical care available right there during their excursion, and a duty to make sure that there was emergency evacuation right there during their excursion. And Nanjing did none of those things. None, not at all. Now that deals with the standard of care and the breach, which leads us right back to the issue that was the one that led to the trial court decision, and the one that we've been debating today. Could reasonable jurors look at all these facts and say, well, okay, I understand Nanjing says there's no duty. I understand the Board of Regents says that, and that this is not a school activity. I understand that it's not a school activity. That's their argument, not a school activity. Gets me talking about duty, too. The reasonable jurors could say, well, sure, it's a school activity. How could it not be a school activity? When they fit it in their schedule, did everything possible to make sure that it could go forward, and gave the permission without which the trip would have been an impossibility. Of course that's a school activity. Now, some reasonable jurors could say, no, I don't buy it. But that's fine. I don't mind if some reasonable jurors could reach a different decision. It's simply, in general, could reasonable jurors decide that this is a school activity? And if they can do that, then you have the trigger for what everybody seems to agree. Well, I take that back. What my colleague, Ms. Woner, said, of course there is a duty. And what they said in their answering brief, both of them said in the answering brief, there is a duty. That leads us back to the duty question. And I think we've resolved the duty question sufficiently that all you need is the factual trigger. Is this a school activity? Reasonable jurors could say that it is. And that's what really matters in this case. The other thing that matters is the case itself. It's important. It's extremely important. There's just hardly any precedent on this, which is shocking considering the hundreds of thousands of students that travel abroad from the United States to very dangerous locations in Africa, Asia, even in Europe, South America. They go in danger all the time, and there's no guidance about duty. We've got exemplary information from Dr. Hoffa. We've got standards that are in place, and you just sort of get stunned silence from the Board of Regents in Nanjing when they say, well, there's standards of care here. This case is important, Your Honor. Thank you very much.
Thank you all for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, the court will stand in recess in preparation for our next argument. Thank you.